I wanted to talk about legislative declarations that are used in urgency and special statute bills, and why more justification is necessary in those bills. California courts are occasionally faced with scrutinizing legislative determinations that are set forth in bills that are enacted as either urgency statutes or as special statutes. Whether it's a statement to justify an urgency statute or a statement to justify a special statute, the judicial branch can and does review whether the legislature has provided a sufficient explanation to justify the need for that urgency statute or that special statute. However, just because the statement is there that a particular bill is a special statute or is an urgency statute does not mean that the judiciary will automatically accept that designation. And it also doesn't mean that the judiciary won't try and evaluate the merits of either of those statements. Because the courts in this state are allowed to look beyond the statements contained in these bills for urgency clauses and special statute clauses, I think it's imperative that legislators, as their authors of bills, assist the attorneys at the Office of Legislative Counsel to develop appropriate justifications so that the courts can easily uphold these provisions and these designations of urgency statutes or special statutes. In other words, I think that there ought to be sufficient justification or more than sufficient justification on the very face of the bills and not just the standard language that's often used in urgency or special statute bills. Specifically, I think there needs to be a concise but thorough explanation to provide the basis for either that urgency clause or that special statute designation. Because without that justification, these bills could be in jeopardy concerning those designations. As you might be aware, both urgency statutes and special statutes are constitutional grants that are found in Article 4 of the California State Constitution, and they're properly subject to judicial review. Because of this review by state court judges, legislators should make it as easy as possible for the courts to uphold these legislative designations or determinations and understand the purpose of doing so and the intent of the legislature. I think if there's an insufficient justification, then a court may not uphold that designation despite the obvious intent of the legislature. Just because there's a short statement contained in a bill's plus section at the end of the bill in uncodified language doesn't necessarily mean that the courts will automatically agree. Rather than forcing the courts to make an educated guess or to infer what the legislature intended, simply be clear by providing appropriate findings and declarations or other statements of intent to explain why that urgency statute is necessary or that special statute is needed. Obviously, if the legislative branch that does the lawmaking in this state, but in order to properly fulfill that role, the legislature has to make its declaration pursuant to the requirements of the state constitution. So let me talk a little bit further and explain the two types of designations. The first, the most common one is an urgency statute. And in Article 4, Section 8C3, it provides that statutes calling elections, statutes providing for tax levies, statutes calling for appropriations for the usual current expenses of the state, the budget bill, the trailer bills, and urgency statutes shall go into effect immediately upon their enactment. Section 8D of Article 4 also provides that urgency statutes are those necessary for immediate preservation of the public health or safety or peace. A statement of facts constituting the necessity shall be set forth in one section of the bill. In each house, the section in the bill shall be passed separately, each by roll call vote entered in the journal, 2/3 of the membership concurring. Also, it states that an urgency statute may not create or abolish an office, or change the salary, term, or duties of any office, or grant any franchise or special privilege, or create any vested right or interest. So working with the bill's author, the Office of Legislative Counsel will make a determination whether an urgency clause will pass constitutional muster, and if so, how the bill language should be drafted. With an urgency statute, if you read it, you'll always see this language. This act is an urgency statute necessary for the immediate preservation of the public peace, health, or safety within the meaning of Article 4 of the Constitution and shall go into immediate effect. The facts constituting the necessity are, and then they state it. So after that, the bill contains an explanation of the need for that urgency clause. And it's up to the bill author to provide the Office of Legislative Counsel attorneys with language that should go into that section after the facts constituting the necessity are. Unfortunately, these clauses are often too short. Here's an example taken from the 2022 legislative session. In order to pay judgment and settlement claims against the state and add hardship to claimants as quickly as possible, it is necessary for this act to take effect immediately. There should be more explanation contained in this declaration, I believe. A court may not simply accept this one sentence or partial sentence. Instead, a court could look beyond for other evidence to justify the statement. And rather than force judges to engage in that sort of research, include some additional statements, provide the backup or the evidence for that statement about the hardship for claimants. Turning next to the special statutes, Article 4, Section 16 provides in subdivision A, all laws of a general nature have uniform operation. And then in subdivision B of Section 16, it states a local or special statute is invalid in any case if a general statute can be made applicable. So a general statute is essentially a law that pertains uniformly to an entire community or all persons generally, or to the entire state. On the other hand, a special statute is essentially a law that applies to a particular person or place, and California law provides for both of these types of statutes to be enacted by the legislature. Now, under the constitutional prohibition against special legislation, a law is general when it applies equally to all persons in a class founded upon some natural, intrinsic, or constitutional distinction. And then it is special if it confers particular privileges or imposes peculiar disabilities or burdensome conditions in the exercise of a common right upon a class of persons arbitrarily selected from the general body of those who stand in precisely the same relation to the subject of the law. And this is the statement of the California Supreme Court, rendered back in 1891 in the case of City of Pasadena versus Stinson. The more recent California Court of Appeal decision in 2014 in the case of Law School Admission Council, Inc. versus the State of California, the appellate court said, the test for determining whether a statutory classification violates the constitutional provision that a local or special statute is invalid in any case if a general statute can be made applicable is similar to that used to determine a statute's constitutionality under the Equal Protection Clause. The constitutional prohibition of special legislation does not preclude legislative classification, but it only requires that that classification be reasonable. In light of the constitutional limitation on special statutes and the manner in which California courts evaluate a bill's special statute designation, I think here it's also important for bill authors to work carefully with the attorneys in the Office of Legislative Counsel. If the attorneys at OLC determine that a special statute is necessary or appropriate, then they'll draft a section at the end of the bill, and you'll see the following language. The legislature finds and declares that a special law is necessary and that a general law cannot be made applicable within the meaning of Section 16 of Article 4 of the California Constitution because of the following. And so after that, the bill contains an explanation of the special nature of the bill and why in particular a bill of general application will not work in the particular set of circumstances being addressed by this bill. Another example of language taken from a 2022 California legislative session bill, it says the unique island nature or the unique island location of Coronado and its proximity to large military installations require a special law. In addition, the complexities of amending a general plan and a local coastal plan for the city will take significantly longer than 6 months. As a result, a general law cannot be made applicable. Now, here too, I think that there should be more explanation contained in this statement to justify the special statute designation. I don't think a court necessarily has to accept these two sentences. In fact, a state court could likely look for further evidence to justify one or both of these statements. And as I mentioned earlier on the urgency clause statement, rather than forcing state judges to engage in further research, why not simply include in this statement the backup or the evidence for these two claims? You know, for more than 100 years, California courts have entertained challenges to legislation and the legislature's attempts to designate either urgency statutes or special statutes. Now, while some courts have naturally deferred entirely to the legislative declarations contained in these clauses, I think that the better approach is for bill authors to provide plenty of explanation to justify these designations, and then no one has to be concerned that the judicial branch won't uphold what the legislature intends in these special statute or urgency clause statutes.